right, good morning, everybody. My name is Caitlin Shugart-Schmidt, and I am the editor-in-chief of the George Washington Law Review. And I have the pleasure of welcoming each of you here today to our second day of our 2017 Symposium, The Challenge of Crime in a Free Society 50 Years Later. Last night, we heard stories personally from those who worked on the 1967 Commission, who helped us frame where we've been and what we've tried in the past. Thanks to their comments, today, we're ready to hear from a terrific slate of speakers about where we're headed, about what our future might or could hold with regards to criminal justice reform. To start us off, we'll hear opening remarks from Dean Roger Fairfax, our symposium co-host. Dean Fairfax is the Jeffrey and Martha Cohn Senior Associate Dean for Academic Affairs and a research professor of law here at the George Washington University Law School, as well as the director of the brand new GW Criminal Law Initiative. His research focuses on discretion in the criminal process, the grand jury, prosecutorial ethics, and criminal justice policy and reform. His scholarship has been published in leading law journals, books, and his edited volume, Grand Jury 2.0, Modern Perspectives on the Grand Jury. He teaches courses in criminal law and procedure, ethics, and criminal law policy. Previously, Dean Fairfax served as a federal prosecutor in the Public Integrity Section of the Criminal Division of the U.S. Department of Justice, practiced at a private firm, and clerked for Judge Patty B. Saris of the U.S. District Court for the District of Massachusetts, who we were fortunate enough to hear from last night, and Judge Judith W. Rogers of the U.S. Court of Appeals for the D.C. Circuit. He is an elected member of the American Law Institute, a fellow of the American Bar Foundation, and a former member of the Governing Council of the ABA Criminal Justice Section and the Board of Trustees of the Maryland Office of Public Defender. Please enjoy.
Thank you, Caitlin, for that wonderful introduction, and welcome to GW and the George Washington Law Review Symposium, The Challenge of Crime in a Free Society 50 Years Later. I really want to thank you all for being here. We have a wonderfully engaging set of discussions planned for the day, and I hope that you enjoy them and are inspired. And as I told some of the participants at dinner last night, this symposium has been on my to-do list for 10 years now. And I know we all have those to-do lists where you say, this year I'm going to hire a personal trainer, I'm going to write my novel, or organize all my digital photos. Well, this has been on that sort of to-do list for me, and I'm glad we were able to do it at the 50th, even though I set forth to do it at the 40th. I'm so thankful to be able to collaborate with the George Washington Law Review to at long last make this symposium a reality. And the reason for my longstanding interest in the Johnson Crime Commission traces back to some scholarly work that I've done on the history of criminal law reform movements going back to the progressive, capital P progressive criminal justice reform agenda in the early 20th century. And I've also studied the work of private law reform coalitions and government-sponsored crime commissions during the interwar period, including the Wickersham Commission and the American Law Institute's various model code projects. And that research eventually led me to the Johnson Commission, the subject of today's symposium. President Lyndon Johnson established the Commission on Law Enforcement and the Administration of Justice in 1965 and appointed as chair Attorney General Nicholas Katzenbach. And much like the participant roster for today's symposium, the Johnson Commission included the leading lights of the academy and the bar. Commissioners included the likes of Kingman Brewster, the president of Yale, Leon Jaworski, who would later become the Watergate special prosecutor, Lewis Powell, who would become Associate Justice of the United States Supreme Court, William Rogers, a former Attorney General who would become Secretary of State, Herbert Wexler, the renowned Columbia law professor who's known as the father of the Model Penal Code, and Whitney Young, the Executive Director of the National Urban League. One of the commissioners had a uniquely GW law connection. Judge Luther Youngdahl of the U.S. District Court for the District of Columbia served as a commissioner, but it must have been difficult for him balancing those duties with the desire to play with his young grandson Todd, and the students in the room will know him as Professor Todd Peterson, whose grandfather served on the commission. And Professor Peterson was here yesterday and brought the original of the report that his grandfather bequeathed to him when he passed away. And it had the original notes from his grandfather on that report. And so he was very moved by the fact of the symposium here. The executive director of the commission was James Vorenberg, who would go on to become dean of Harvard Law School. And one of the staffers was Gerald Kaplan, a former member of the GW Law faculty. So we're proud of that connection to GW Law. And the commission had the benefit of a number of staffers, consultants, and advisors, including Elizabeth Bartholet, Sheldon Krantz, Susan Shapiro, and the former Chief Judge of the D.C. Circuit, Patricia Wald, the four distinguished panelists we heard from yesterday afternoon. And looking at the Johnson Commission, it had a very broad mandate, including a comprehensive review of American criminal justice. The commission's work was being done against the backdrop of rising crime rates in the 1960s, as well as continued urbanization and ever-increasing racial, societal, and political tensions. And as noted criminologist Todd Clear observed, the Johnson Commission might well be seen as the first foray of politics into the crime policy arena. The commission published its report in 1967 with a great deal of attention and fanfare. The report spanned 12 substantive chapters covering a snapshot of crime in America, juvenile delinquency and youth crime, police, courts, corrections, organized crime, narcotics and drug and alcohol abuse, control of firearms, science and technology, and a national strategy on crime. The report contained over 200 recommendations to cities, to states, to the federal government, and to individual citizens and their organizations for the reform of criminal law and the criminal process. As a recent National Public Radio story on the 50th anniversary of the commission observed, one of those 200 recommendations you'll be familiar with, it was the establishment of a national emergency number 911. But that's just one example of the many recommendations that came out of the report. Most profoundly, I think, the report called for the professionalization of policing in America and a recognition of the societal factors that give rise to criminal conduct and the uneven application of police powers in different communities. In the words of Harvard historian Elizabeth Hinton in her recent book tracing the development of mass incarceration in the United States, the Johnson Commission report, quote, offered the legislative proposals that laid the groundwork for a revolution in American law enforcement, linking crime control and anti-poverty policies in new and innovative ways. Furthermore, the 1967 report concluded in language that I think is just as relevant today, and I'll quote from the report. Taking together these recommendations and suggestions express the Commission's deep conviction that if America is to meet the challenge of crime, it must do more, far more than it is doing now. It must welcome new ideas and risk new actions. It must spend time and money. It must resist those who point to scapegoats and who use facile slogans about crime by habit or for selfish ends. It must recognize that the government of a free society is obliged to act not only effectively, but fairly. It must seek knowledge and admit mistakes. So I think it's vitally important to honor the past as we do in this symposium, but the more critical and urgent task before us is to try to shape the future. And that's why this symposium is so gratifying for me. We get to tackle in this symposium those issues of policing and prosecution and prisons and punishment and policy, I guess all the P's, with the scholars and policymakers and policy advocates I most admire and who have been some of the most cutting edge voices in the renewed conversation on crime policy in America. We've seen over the past decade unprecedented bipartisan cooperation on addressing these issues. And even when these bipartisan efforts haven't borne fruit, the fact that policymakers and advocates are willing to move beyond the tough on crime rhetoric of yesteryear, which fueled the mass incarceration crisis we face today, shows significant progress. And to be sure, there are very real concerns about retrenchment. And while there is reason for some pessimism, and I'm sure we'll get into that in some of today's discussions, I remain optimistic that many in the United States have begun to experience a fundamental change in consciousness around critical criminal justice issues. Sparked in part by Michelle Alexander's popular landmark book, The New Jim Crow, and those that have followed, including books by James Forman and John Pfaff, Americans have begun to take note of these issues. For the past 15 years, they've been watching television dramas like The Wire that go beyond the traditional police procedural and put a microscope to the complex problems that we must confront collectively. They've been watching cable and Netflix documentaries like 13th and The House I Live In. They've begun to make the connection that money spent on incarceration is money not spent on schools and roads and other societal investments. And they're beginning to respond to the opioid crisis with the compassion and public health orientation that should have marked the response to the crack cocaine crisis in the 80s and 90s. Some prosecutors and other candidates running for office are talking about enforcement policies to the voters and incarceration rates and other critical issues of criminal justice. And recent high-profile killings of mostly unarmed African Americans has sparked a national conversation on policing and race and spawned the next generation of civil rights advocacy, particularly among millennials. So this momentum need not be lost. And I think if legal scholars and policy advocates and policy makers keep these issues front and center, we can transform American criminal justice just as the Johnson Commission attempted to do 50 years ago. And this symposium is a part of that effort. So before I introduce our keynote speaker, I'd like to just say a quick word of thanks to the panelists and speakers who came from all over the country to participate in this special event. I'd like to thank Dean Morant for his support of the symposium, the faculty and staff who supported this event, including especially the communications office. I'd like to thank the George Washington Law Review and its editors, led by Caitlin Shugart-Schmidt and Jill Greenfield, and all of the symposium editors. And I'd like to thank George Washington Law Review faculty advisor, Professor Brad Clark. And last but not least, I'd like to thank my criminal law students, some of whom I see here in the audience, for allowing me to cancel class today. And yes, I do teach criminal law at 8:50 in the morning on Friday. So thank them for being here. And without further ado, I'd like to undertake the honor of introducing our distinguished guest, Representative Bobby Scott of Virginia. And Congressman Scott is currently serving his 13th term representing the citizens of Virginia's 3rd Congressional District in Congress. Prior to serving in Congress, Congressman Scott served in the Virginia House of Delegates and in the Senate of the Commonwealth of Virginia. In Congress, he serves as the ranking member of the Committee on Education and the Workforce. In his capacity as the senior Democrat on the committee, he is leading the fight for access to quality, early, secondary, and higher education for all of America's children. In 2015, he was one of the 4 primary negotiators of the Every Student Succeeds Act, which reauthorized the Elementary and Secondary Education Act for the first time in 13 years and replaced the No Child Left Behind Act. He is also working to ensure that American workers are treated fairly, paid a decent wage, given a safe working environment, and provided access to affordable health care. Congressman Scott is also fighting to reform the nation's criminal justice system. He has introduced the Youth Prison Reduction through Opportunities, Mentoring, Intervention, Support, and Education Act, or the PROMISE Act, which would provide resources to state and local governments for evidence-based, data-driven strategies to prevent juvenile crime. Also in 2015, he and Republican Congressman Jim Sensenbrenner co-authored the Safe, Accountable, Fair, and Effective Justice Act, or the Safe Justice Act, which has been recognized as one of the most comprehensive criminal justice reform bills in a generation and has attracted significant support from across the political spectrum. He served as ranking member of the House Judiciary Committee's Task Force on Over-Criminalization in the 113th Congress, which undertook a sustained study of the proliferation of federal criminal laws and the concomitant effects of those laws. Congressman Scott resides in Newport News, Virginia. He's a graduate of Harvard College and Boston College Law School. He also served in the Massachusetts National Guard and the United States Army Reserve. And I could say personally, as someone who has testified before Congressman Scott and his fellow colleagues in the House on matters involving criminal justice, I could truthfully say that he is one of the most thoughtful, pragmatic, dedicated, and respected legislators we have in Congress, and is a visionary leader. And we're so fortunate to have him here with us this morning to kick off this tremendous agenda. So please join me in welcoming Congressman Bobby Scott.
Thank you, Dean Fairfax, for your very kind and generous introduction. About halfway through, I was reminded of something we frequently say on the floor of the House, and that is, I yield the gentleman some more time. I want to thank the George Washington Law Review for bringing lawyers, policy thinkers, and law students together to discuss the state of criminal justice reform efforts and the challenges we face, particularly in light of the 50th anniversary of President Johnson's Commission on Law Enforcement and Administration of Justice. Looking back at that report, it's like Groundhog Day. And the fact is that there's really very little debate on crime policy in America. The debate is on purpose of crime policy. Are we trying to reduce crime and save money? We know what to do. Or are we trying to codify a bunch of simple-minded slogans and sound bites to help politicians get elected? We know what to do. Once we've decided the purpose, the rest is easy. The final report, the Johnson Report, resulted from thoughtful work of the Johnson Commission titled The Challenge of Crime in a Free Society. President Johnson called that report the most comprehensive and detailed program for meeting the challenges of crime ever proposed in this country. The report called for sweeping change for police, courts, and corrections. It issued 7 objectives and more than 200 specific recommendations. The recommendations listed in the report continue to be relevant to our discussion today about criminal justice. In a speech given by President Johnson on the report, he stated that we cannot tolerate an endless, self-defeating cycle of imprisonment, release, and re-imprisonment, which fails to alter the undesirable attitudes and behaviors. We must find ways to help the first offender avoid the continuing career of crime. That report specifically recommended, quote, removing mandatory minimum prison terms, heard that before, long maximum prison terms, and ineligibility for probation and parole. It recommended that instead of warehousing people who use drugs and violate the law, we should offer alternatives, including treatment to achieve rehabilitation. Just parenthetically, I think most people recognize, if they think about it, that the criminal justice system isn't going to reduce drug use. I mean, you cannot impose enough sentence to get people to change behavior. You know, a few years ago, we've altered it a little bit, the difference in punishment for crack and powder. For small amounts of crack, you get 5 years mandatory minimum. For 500 grams, for 499 grams of powder, you can get probation. 5 years mandatory, probation. And how many people have you heard say, well, I stopped using the crack, I stick with the powder? No, 5 years mandatory won't change behavior, so how much more? And so the idea that you're going to use the criminal justice system to try to change drug behavior is patently absurd. But the commission also investigated children's involvement in criminal activity, and President Johnson spoke of legislating, quote, programs developed to provide new approaches to the prevention and control of juvenile delinquency and to train needed personnel. Ultimately, President Johnson said the long run approach to crime prevention lies in focusing on jobs, education, and hope. Unfortunately, we later abandoned these goals, starting in, this report was 1967. 1971, we started up the war on drugs and made the choice to treat drug use as a criminal offense rather than a public health issue. In the 1980s, we talked about Sentencing Reform Act of 1984. The approach led to abolishing parole in the federal system in violation of one of the principles and recommendations, making sure that federal prisoners could no longer get early release for good behavior. And the Anti-Drug Abuse Act of 1986, where you found the 101 crack powder cocaine disparity, mandatory minimums, draconian mandatory minimums that often landed on girlfriends who would be getting 10, 20, 30 years in prison. That thing was so absurd that you remember a couple of years ago, President Obama started a commutation program where if you had served 10 years and you were a low-level, nonviolent, essentially first offender, that he would consider you for commutation, time served. That sounds reasonable, but what ought to occur to you is, what in the world did a low-level, nonviolent first offender get so much time that after 10 years, they still need help from the president? Low-level, nonviolent first offender. And that's because the mandatory minimums ended up giving those low-level, nonviolent first offenders decades in prison. In the 1990s, these responses to widespread drug use culminated in the 1994 Omnibus Crime Bill, which enacted draconian and bizarre mandatory minimum sentences for federal crimes, incentivized states to abolish parole, created mandatory minimums, over 60 new death penalties, including death penalties for juveniles, on and on. It had about every poll-tested slogan and soundbite you can imagine was part of that legislation, passed with a nice, overwhelming majority. 50 years after the commission, our approach to crime has not been, as President Johnson envisioned it, and in his words, focused on jobs, education, and hope. Instead, sadly, we've built upon the tough on crime approach, which is taken by the 1994 Omnibus Crime Bill. And we have continued on that for the past few years. Once incarcerated, we offer limited programming to treat substance abuse and real job skills. The 1994 Crime Bill abolished Pell Grants for prisoners. Studies have shown that give a Pell Grant a prisoner when they go to college, they're so much less likely to come back to prison that we save more money in avoided prison costs than you spent in the Pell Grants. But the slogan, if my child can't get a Pell Grant, the prisoner shouldn't get a Pell Grant, and away they went. Slogans over policy. 4 decades after Nixon declared a war on drugs, and all of those slogans and sound bites have created a situation where Michelle Alexander and others have described the mass incarceration. We represent 5% of the world's population, 25% of the prisoners, highest incarceration rate in the world, so much so that some studies have calculated that our incarceration rate is actually counterproductive. Said anything over about 430 per 100,000, you're getting so little value in terms of crime reduction that if you count the other things, you're actually adding to crime, because you've got so many children being raised by parents in prisons. You've got so many people with felony records, can't find jobs. You're using so much of the Justice Department budget, as Dean Fairfax said, on prisons when it could be spent on things that evidence shows will actually reduce crime and save money. Then anything over about 430 per 100,000 is counterproductive. Our rate is about 700 and some per 100,000. In the African-American community, about 2,200. And in some states, they lock up African-Americans at a rate of 4,000 per 100,000. And that's not free. That's money that could have been spent effectively on other initiatives. The racial disparities, as I indicated, are staggering. On the positive side, it would appear that we're trying to do something a little different. On the state level, not the federal level, on the state level, they have taken some actions. 32 states have chosen a different path and have reduced crime and saved money by taking money out of prisons and putting it into prevention, early intervention, and rehabilitation. The first major example of that was Texas. Their Appropriations Committee was told that they needed $2 billion new money to deal with the rising prison expansion. $2 billion, that's one state, $2 billion. Somebody said, well, maybe if you spend about 10% of that on prevention, early intervention, rehabilitation, you might not have to spend all $2 billion on prisons. So they tried it and looked up. It worked so well that they didn't need to build any new prisons. In fact, they were able to close some of the prisons they had. Now, this creates an interesting coalition because you're reducing crime and saving money, and that's something liberals and conservatives can all agree on. And so there's been bipartisan support for doing something intelligent on crime. Conservatives even call it, quote, right on crime, playing on correct and the political right, and promoting intelligent, thoughtful approaches. Unfortunately, on the federal level, we have been trying to go in the right direction, but most recent action by the Attorney General was to change the sentencing policy and the charging policy. Instead of under the Holder memo, you charge what makes sense, try to avoid the mandatory minimums so that if after conviction an intelligent sentence can be imposed, to reduce the application of the draconian mandatory minimums. Attorney General Sessions issued a memo ending that policy and changing to one where you charge the maximum possible sentences, including those that carry the biggest, most draconian mandatory minimums. We're all in an environment where the president in July told police officers not to be too nice when placing people under arrest and transporting them. In this climate, we really have to go back to the choice. Are we going to be doing the slogans and sound bites, or are we going to be doing policy that can reduce crime and save money? We know that we know what those slogans are, and we saw them all, like I said, in the '94 crime bill: 3 strikes and you're out, mandatory minimums. And if you can get it to rhyme, it's even better. If you do the adult crime, you do the adult time. Everybody here knows that all of the research shows that codifying that little rhyme will actually increase the crime rate, because an adult court judge has 2 choices: let the guy walk out of court or lock him up with adult murderers, robbers, and drug dealers. And a couple of years later, guess who is more likely to be back in the system? That's why we're trying to get a more thoughtful approach. That's why we introduced the Safe Justice Act. We're going to be reintroducing it again. Going through the Safe Justice Act, now I hadn't read the 50-year-old report, and I'd seen versions of it, but going through the report and looking at the Safe Justice Act, it has a lot in common. Safe Justice Act starts with investments in prevention and early intervention to get young people on the right track, to keep them on the right track. It has police training. When you get to the end of the debate about whose fault it is and what the causes are of all of the police problems that we're having debates about, when you get to the end of it, you're going to need money for training. So we skip the debate and have the pot of money there. When you get to the end of the debate, let us know there's money for training. An encouragement to have risk-based bail rather than wealth-based bail. If you're wealthy, you get out on bail. If you're poor, you stay. Have it risk-based. If you're dangerous, you ought to stay. And if you're not dangerous, you ought to go. There are significant disadvantages for people that end up in jail for 2-3 months waiting for trial in terms of whether or not they're going to have an apartment to go back to and whether they're going to have a job to go back to. And so we want to make that risk-based rather than wealth-based. When you get to court, have problem-solving courts like drug courts there to try to solve the problem rather than to just put somebody in jail, come back. When you get to sentencing, eliminate virtually all of the mandatory minimum sentences, particularly for drugs. Let the judge impose a sentence that makes sense. When you get to prison, rehabilitation for everybody, and when you get out, second chance to make sure that the chances of coming back are minimized. Everything that costs money, like prevention programs, police training, and everything, could be paid for by reallocating the money you save in mandatory minimums. In fact, you probably can't spend all the money you'll save on mandatory minimums because that will be in the billions. And so that is a thoughtful approach based on evidence, and if you go back to the 50-year-old report, that's what was in the report. Frankly, if you're going to have any kind of criminal justice reform, and there are a lot of different ideas about it, I like the idea of kind of evaluating what the purpose is, and things like how do you treat drugs? Do you treat it like the war on drugs, or do you treat it like a public health situation? What do you do for mass incarceration? Are you reducing mass incarceration, or are you adding to mass incarceration? And then you can really tell where a bill is going by looking at what they do with mandatory minimums. If they eliminate mandatory minimums, you're doing something about mass incarceration. If you're expanding mandatory minimums, obviously that's going in the wrong direction. Some of the bills would reduce the mandatory minimum, but then expand the number of people who are eligible to get it. And you count it up, you don't know whether you're going up or down in terms of mass incarceration. Is there a disparate impact on race? We know we have racial disparities. Do you make them better or worse? What do you have for reentry to make sure people who are in prison are less likely to come back? And finally, I think just an overview, is the bill based on politics, slogans, and sound bites, or is it based on research and evidence? That can give you an idea of what to expect out of the legislation. Like I said, it has broad bipartisan support. Many people, very conservatives, like the idea that you're going to save money. Liberals like the idea that you're investing in prevention, early intervention, and eliminating a lot of the mandatory minimums. There are other bipartisan ideas that, like I said, would fail on just about every one of the measures I just outlined. We'll see what happens. We're going to have a forum on it on Thursday and introduce the bill shortly after that, and we'll just see how it goes. But I think the thoughtful process that they went through 50 years ago will be helpful in promoting the bill. One of the areas where you can actually reduce crime most effectively is in juvenile crime. Again, the slogans and sound bites, trying more juveniles as adults and locking them up with adults and all of the other things, the draconian approaches. I think most of the evidence is just the other way. There was an Attorney General's report, which nobody read because it came out the same week of the Sandy Hook shootings, that talked about how to deal with children exposed to violence. The traumatic effect of violence makes them more likely to commit crimes, and they found that if you intervene, you can reduce the likelihood that they will be involved in the criminal justice system. The interesting thing about that report is that they only mentioned the criminal justice system twice. They mentioned it in zero tolerance policies are ignorant and stop trying more juveniles as adults. Everything else in the report dealing on reducing crime was prevention, early intervention, and rehabilitation. And it's that kind of attitude that I think we need to be looking at. I know right after the Columbine shootings, the Speaker of the House wanted to form a little commission. And I remember Dick Gephardt, who was the Democratic leader at the time, came to me and said, "Bobby, you've been working on juvenile justice. I think they're trying to set us up, and they wanted this bipartisan task force. And if we go along with it, we may be stuck with some simple-minded initiatives that we may not want. What do you think?" And I said, "Dick, if they have a thoughtful process, our side will win." We had weekly meetings, behind closed doors, no press. Everybody, 8 Democrats, 8 Republicans, everybody can invite witnesses. And at the end of the 8 weeks, I said that it is interesting that not one witness said anything good about trying more juveniles as adults, mandatory minimums, longer sentences, zero tolerance, or anything else in the criminal justice system. All of them said that if you want to reduce juvenile crime, you have to, it's all prevention, early intervention, and rehabilitation. And after I said that, one of the Republicans walked out because he had been had because our side had won. And Bill McCollum, conservative Republican from Florida, who was chair of the crime subcommittee, and I was the ranking member of the crime subcommittee, came up with a bill to invest money in juveniles, particularly in juvenile courts. The judges, conservative and liberal, were complaining that when a child comes in, all they can do is put them on probation and warn them and threaten them, but they had no services to provide. We had funding for those services so that they could actually deal with the criminal justice system. But it just showed that the thoughtful process is always going to come up with the same conclusion: prevention, early intervention, and rehabilitation. The Johnson report said that America's best hope for reducing crime is to reduce juvenile delinquency and youth crime. Get young people on the right track and keep them on the right track. You reduce crime and save money. Some of it looks like it could have been written last week because it falls right into the debate of whether we're going to be reducing crime or codifying slogans. They mentioned that the some of the things we know, the delinquency rates are high amongst children from broken homes. Delinquents come from backgrounds of social and economic deprivation. Inescapable that juvenile delinquency is directly related to conditions of poverty. They went on to say when all the stuff that we know that disproportionately affected by poverty, and if you can eliminate the root causes of crime, you can have a positive effect on crime. And clearly it is with young people that prevention efforts are most needed and hold the greatest promise. The report went on to say that it is simply more critical that young people be kept from crime, for they are the nation's future. Their conduct will affect society for a long time to come. They have not yet set their ways. They are still developing, still subject to the influence of socializing and institutions that structure, however skeletally, their environment, family, school, gang, recreation programs, job market. But that influence to do the most good must come before the youth has become involved, become involved in the criminal justice system. Once the juvenile is apprehended by police and referred to the juvenile court, the community has already failed. Subsequent rehabilitative services, no matter how skilled, have far less potential for success than if they had been applied before the youth's overt defiance of the law. That's what we know already. So now, even though many of the issues of the report are still with us, we're still working to try to improve the situation. We're in the process of reauthorizing the Juvenile Justice and Delinquency Prevention Program. That program has been reauthorized since 1974 5 times, but it hadn't been reauthorized for over a decade. We're trying to reauthorize it. The House has passed the reauthorization twice, has not diminished the core protections, and as a matter of fact, requires for the first time that state juvenile justice plans take into account scientific research on adolescent development. That's something that'd be nice to have as you develop policy, eliminating the slogans and sound bites and getting into research. As I said, the House has passed the bill twice, last Congress and this Congress. It's over in the Senate, held up by a couple of senators who just love locking up juvenile status offenders. Status offense, that's an offense, it's only an offense because of the status of the defendant as a juvenile, stuff like truancy, beyond parental control, things like that, underage drinking. The research shows there's no constructive purpose in locking somebody up for committing a status offense. There's a way around that, the valid court order. You order the child to go to school, he doesn't go to school. You lock them up for violating the court order. The underlying offense was not going to school. Some like that exception. Most of the experts, virtually all of the experts, say that loophole has to be closed. and because one or two senators want to keep that loophole open, we've been unable to actually pass the juvenile justice and delinquency prevention reauthorization. We're still working on it. It's virtually unanimous in terms of support, but hopefully we'll get that done in the next couple of weeks. And there's bipartisan support, as indicated. It passed the House with over 400 votes. And there are at least 90-some senators supporting the bill as it is. But you know how the Senate works. 99 senators isn't enough to get a bill passed. You got to get unanimous consent or exhaustion, as it's explained to me. But we have a lot of things that we're working on. The choice is still the same choice that we started with over the last 50 years. You can choose research and evidence, or you can choose slogans and sound bites. Someone once said, to quote, "History doesn't repeat itself, but it does rhyme." We're at the crossroads. 50 years ago, we had a blueprint on what to do on criminal justice reform. We essentially ignored it for 50 years. We took a different path, and that led our growth to become the biggest incarcerator in the world. Lives have been ruined. Millions of dollars that could have been spent constructively has been wasted and over incarceration. And now we've reached a point where the case has been made that we must reform our ways if we want to be the beacon of freedom and justice that we think we are as a country. We have the research, we know what to do, and the only question is whether we have the political will and wisdom to make the right choice. Thank you very much.
So, Congressman Scott, thank you so much for those remarks. I know that you earned your degrees at Harvard and Boston College, but I want you to make two promises. One is that you'll come back to GW Law School, and that when you come back, you'll consider wearing this GW Law silk tie when you come back to visit us. So thank you so much.
Appreciate it.
Really appreciate it. Thank you.